There are several defenses to contract enforceability, including lack of capacity. Lack of capacity may be based on infancy, intoxication, or even mental illness. In Faber versus Sweet Style Manufacturing, we explore what is required to assert lack of capacity based on a mental illness. Isidore Faber was diagnosed with manic-depressive disorder. From August to October of 1961, Faber was in a manic phase. He refused to see his doctor and began acting erratically. Before this time, Faber had been generally frugal and cautious, but in September, he purchased expensive cars and contracted to buy several pieces of land. On September 23rd, Faber contracted to purchase a plot of land from Sweet Style Manufacturing Corporation to construct a drugstore. Even though closing wasn't set to occur until October 20th, Faber quickly engaged a title abstract company, hired an employee to head the building project, erected a "Coming Soon" sign on the land, hired an architect, filed a mortgage application, hired laborers to begin digging, and filed plans with the city. On October 8th, Faber was hospitalized in a mental institution. Faber brought suit to have the contract with Sweet Style rescinded. Faber claimed that he was mentally incompetent when he entered the contract. Sweet Style counterclaimed for specific performance. At trial, Faber's doctor testified that Faber was incapable of reasoned judgment on September 23rd. However, Sweet Style's expert psychiatrist testified that Faber's judgment was intact on September 23rd. The court considered the parties' arguments.